Here's something worth knowing before we dive in. Section 8 of the DPDP Act alone contains the bulk of a data fiduciary's operational obligations. And yet, many organizations rushing toward compliance skip straight to technical controls without ever reading this section carefully. That's like building the walls of a house before finishing the foundation. In this chapter, we are going deep into the Act's actual legal text for the first time, chapters 1 and 2 specifically. You'll walk away understanding exactly when the Act commences, the legal grounds that allow processing in the first place, what a valid notice must contain, how consent must actually be obtained, situations where consent isn't even required, and the full weight of obligations sitting on every data fiduciary's shoulders, including special protections for children's data. This is dense material, I won't pretend otherwise. But we'll work through it the same way we've handled everything so far. Real scenarios, plain language, and constant connections back to what you already know. Let's begin. Alright, let's open the actual Act now. Not summaries, not commentary, the real legal text. Chapters 1 and 2 together form what I like to call the operational backbone of DPDP. Chapter 1 handles the housekeeping, when the law applies and to whom. Chapter 2 is where the real substance lives, the actual obligations fiduciaries must fulfill. Here's a mistake I see constantly among professionals rushing into compliance work. They jump straight to building consent banners and privacy policies without ever reading Section 8 properly. That's like a doctor prescribing medication without reading the patient's chart first. I remember sitting with a compliance team who'd built an entire consent management system, genuinely impressive technically, but it turned out their legal basis for processing certain data didn't even fall under Section 6 consent requirements. It qualified under Section 7's legitimate uses instead. They'd solved the wrong problem entirely. That's exactly why we're spending real time on this chapter. Get Sections 4 through 10 right, and you'll have built your compliance program on solid legal ground rather than assumptions. Think of this as reading the actual contract before signing it, rather than trusting someone's summary of what it probably says. Let's start with what sounds like the most boring section in any law, and yet carries real practical weight, Section 1. This section tells us the Act's official name, its territorial extent, and critically, when different provisions actually take effect. Here's the detail that trips up even experienced professionals. DPDP wasn't activated all at once. The Act received presidential assent in August 2023, but different provisions commence on dates notified separately by the central government, not automatically on passage. Think of it like a building being handed over floor by floor, not all at once. I had a client CEO ask me in late 2023, "We're fully DPDP compliant now, right, since the Act passed?" I had to explain, not quite. Several operative provisions were still awaiting notification. That gap between passage and actual enforcement created genuine confusion across Indian industry for months. Why does this matter practically? Because compliance deadlines aren't fixed at the moment a law is passed. They depend entirely on government notification timing. With the DPDP rules notified in late 2025, staggered implementation timelines kicked in for various provisions. So here's a habit worth building starting today. Don't just track is DPDP in force, track which specific sections are currently in force and which compliance deadlines apply to your organization specifically. That distinction between passage and commencement isn't legal trivia. It directly determines your actual compliance runway. We already explored the practical meaning of key terms back in Chapter 3, fiduciary, processor, principal, personal data. But Section 2 is where all of that lives formally in the Act's actual text. So let's revisit it briefly through a slightly different lens. Precision. Here's why precision matters so much in legal definitions. Think of definitions like the rules of a board game. If two players interpret a rule differently, the entire game breaks down into arguments. Legal compliance works exactly the same way. Ambiguous interpretation of a definition can mean the difference between compliant and non-compliant practice. I once worked through a dispute where two departments within the same company disagreed on whether certain employee data qualified as personal data under the Act's definition. Sounds simple, right? It took real analysis of Section 2's language to resolve definitively. Rather than repeating every definition again here, since we covered the practical meanings thoroughly in Chapter 3, think of Section 2 as your reference dictionary going forward. Whenever you hit an ambiguous compliance question anywhere in this course, your first instinct should be returning here to the Act's actual defined language, not assumptions or general privacy knowledge from other jurisdictions. That habit alone, checking definitions before assuming, will save you from countless compliance mistakes throughout your career. Now we hit real substance, Section 4, which answers a fundamental question. On what legal basis can anyone actually process personal data under this Act? There are essentially two pathways: consent or specific legitimate uses that don't require consent at all. Think about that structure for a moment. Most people assume privacy law always means asking permission first. But DPDP recognizes that some processing serves purposes so essential or beneficial that requiring consent every single time would be impractical, even harmful. Here's an example I use often. Imagine a hospital receiving an unconscious patient during a medical emergency. Should doctors pause treatment to obtain consent for processing that patient's medical data? Obviously not. Life matters more than paperwork in that moment. Section 4, through its connection to Section 7, allows processing without consent precisely in situations like this. I worked with an edtech platform once whose product team assumed every single data use required a fresh consent pop-up. That's simply not how DPDP works. Once you understand which of the two pathways applies to specific processing, your compliance approach becomes far more targeted and less bureaucratic. So here's the mental framework going forward. For every processing activity your organization conducts, ask first, does this genuinely need consent or does it qualify under one of the legitimate use categories we'll explore in Section 7? That single question shapes your entire compliance strategy for that activity. Before consent can even be meaningful, individuals need to actually understand what they are agreeing to. And that's exactly what Section 5 addresses, the notice requirement. Think of notice as the menu you read before ordering food. You can't make a genuine choice without first knowing what's actually on offer. Here's where DPDP gets specific in ways many organizations aren't ready for. Notice must clearly describe the personal data being collected, the purpose of processing, and how the data principal can exercise their rights, including how to file a complaint with the Data Protection Board. That's considerably more detailed than a vague "we value your privacy" statement. I reviewed a client's existing privacy notice recently. 4 pages of dense legal language nobody would realistically read. Under DPDP spirit, that's a problem, even if technically all required elements existed somewhere in that document. Genuine notice requires genuine clarity, not just legal coverage. Think about a real-life analogy. If a doctor hands you a consent form for surgery written entirely in medical jargon you don't understand, did you really give informed consent? Not meaningfully. DPDP pushes organizations toward that same standard: clear, itemized, understandable communication before any collection begins. Here's a practical exercise worth trying. Pull up your organization's current privacy notice and ask honestly, could a non-technical relative of yours read this and genuinely understand what's being collected and why? If not, Section 5 compliance likely needs real work, not just a legal review. Now we arrive at what many consider the heart of DPDP, Section 6, governing consent. Here's the standard the Act sets. Consent must be free, specific, informed, unconditional, and unambiguous, with clear affirmative action. Notice how many adjectives that is, each one closing a loophole organizations previously exploited. Let's unpack unconditional specifically because it surprises people most. Imagine a mobile game that refuses to let you play unless you also agree to share your contacts and location, features entirely unrelated to actually playing the game. That's conditional consent, and it's explicitly prohibited under DPDP. I worked with an app development client whose onboarding flow essentially forced users through 7 consent toggles before allowing basic app access. When I asked why, they said, more data helps our analytics. That's precisely the mindset DPDP is designed to eliminate. Consent bundled with unrelated conditions isn't valid consent at all. Here's another critical detail: withdrawal. Consent must be as easy to withdraw as it was to give. Think about services where signing up takes 30 seconds, but cancelling requires phone calls, retention offers, and multiple confirmation screens. That asymmetry directly violates this principle. So here's a question worth asking about your own organization's consent flows. Is granting consent effortless while withdrawing it deliberately difficult? If yes, that imbalance itself represents a compliance gap, regardless of how legally polished your consent language might otherwise appear. Remember that second pathway we mentioned back in Section 4? This is it, Section 7, which lists specific situations where processing personal data doesn't require consent at all. Think of these as carefully carved exceptions, not loopholes, each one addressing a genuine practical necessity. Let's walk through a few that matter most in practice. Voluntary provision of data by an individual for a specific purpose. Think of someone handing over their business card at a networking event, expecting reasonable follow-up contact. Employment-related processing. Certain HR functions genuinely can't wait for individual consent every time. Medical emergencies. Exactly the unconscious patient scenario we discussed earlier, and processing for compliance with court orders or legal obligations. I remember a corporate client asking, almost hopefully, so we could classify most of our marketing data collection under legitimate uses instead of consent? Absolutely not. And this misunderstanding is dangerously common. Section 7 covers narrow specific circumstances, not general convenience. Marketing generally still requires proper consent under Section 6. Think of Section 7 like emergency exits in a building. They exist for genuine emergencies, not as a shortcut to skip the main entrance whenever convenient. Misusing these provisions to avoid consent obligations creates serious compliance risk, not a clever workaround. So here's the discipline required going forward. Before claiming any legitimate use exemption, ask honestly, does this situation genuinely match one of the Act's specific listed circumstances? Or am I stretching the definition to avoid the harder work of proper consent? That honesty will protect your organization far more than aggressive interpretation ever will. If Section 6 is the heart of DPDP, Section 8 is arguably its backbone. The comprehensive list of what every data fiduciary must actually do operationally. This section is long, detailed, and genuinely demanding. So let's focus on what matters most practically. Fiduciaries must ensure the accuracy and completeness of personal data used for decisions affecting individuals. Implement reasonable security safeguards to prevent breaches. Notify the board and affected individuals of any breach. And erase personal data once its purpose is fulfilled, unless retention is legally required. Here's a real scenario. Imagine a bank still holding a former customer's complete financial history 5 years after that person closed their account, with no legal requirement to retain it. Under Section 8's erasure obligation, that data should have been deleted long ago. I've seen this exact scenario play out with clients who simply never built systematic data retention schedules. Think about accuracy obligations too. If your organization uses outdated personal data to make a lending decision or insurance assessment, and that inaccuracy causes real harm, Section 8 makes that failure your direct responsibility, not an excusable technical glitch. Here's why this section demands genuine operational investment, not just policy documents. Ask yourself, does your organization have actual systems, not just written policies, ensuring data accuracy, timely erasure, and breach detection? Section 8 essentially describes the day-to-day discipline every fiduciary must build into their real operations, continuously, not as a one-time compliance exercise. Now let's address one of DPDP's most protective provisions, children's data under Section 9. The Act defines a child as anyone under 18, notably stricter than many international frameworks that set the threshold at 13 or 16. Here's the core requirement. Processing a child's personal data requires verifiable parental or guardian consent. Additionally, fiduciaries are prohibited from tracking, behavioral monitoring, or targeted advertising directed at children, full stop, regardless of consent obtained. I remember discussing this with an edtech client building a learning app for school students. Their initial monetization plan included personalized ad targeting based on usage patterns, standard practice in many markets. Under DPDP, that model is simply prohibited when children are involved. No exceptions, no clever consent workaround available. Think about why lawmakers drew this line so firmly. Children generally can't fully grasp the long-term implications of data sharing, and parents themselves often struggle to evaluate complex digital consent mechanisms on their behalf. So the Act removes the option entirely for the most exploitative practices rather than relying on consent alone to protect them. Here's a genuinely tricky area worth flagging: age verification itself. How does a platform reliably confirm a user's actual age without collecting even more sensitive data in the process? That tension between verification and minimization remains one of the most actively debated compliance challenges under this section, and one you'll likely encounter directly if you work with any consumer-facing platform. Finally, Section 10 introduces a special category: significant data fiduciaries. Organizations facing heightened obligations because of the scale, sensitivity, or risk associated with their data processing. Think of this as DPDP's way of saying, with greater data comes greater responsibility. Here's how classification works. The government designates certain fiduciaries as significant based on factors like volume of personal data processed, sensitivity of that data, risk to electoral democracy or state security, and potential impact on data principal rights. This isn't self-declared, it's a government notification process, one we'll explore in much greater depth in Chapter 9. Once designated, additional obligations kick in immediately: appointing a data protection officer based in India, conducting periodic data protection impact assessments, and undergoing independent data audits. Think of it like additional safety inspections required for a large commercial aircraft compared to a small private plane. More passengers, more risk, more oversight required. I worked with a large fintech platform anticipating significant data fiduciary designation well before it was formally notified. Their leadership asked me, should we build these capabilities now or wait for official designation? My advice was always build now, because retrofitting a data protection officer function and audit processes under regulatory pressure is far harder than building them proactively. So here's a forward-looking question worth considering for any large-scale platform. Given your organization's data volume and sensitivity, is significant data fiduciary designation a realistic possibility in the near future? If yes, the smart move is preparing for these heightened obligations now, not scrambling once a government notification arrives. Let's consolidate Chapter 4. We opened with Section 1, learning that DPDP's commencement wasn't a single event, but a staggered rollout, and that tracking specific provision timelines matters more than tracking the Act's passage date alone. We revisited Section 2's definitions through the lens of precision, treating them as your reference dictionary throughout this course. We then explored the real operational core, Section 4's 2 pathways for lawful processing, Section 5's demand for genuinely clear notice, and Section 6's strict consent standard: free, specific, informed, unconditional, and easily withdrawable. We examined Section 7's narrow legitimate use exceptions, careful not to stretch them beyond their intended purpose, and Section 8's demanding operational obligations around accuracy, security, and erasure. Finally, we covered Section 9's firm protections for children's data and Section 10's heightened obligations for significant data fiduciaries, organizations carrying extra responsibility because of their scale and risk profile. If you want the fully structured version of this journey, complete with role plays, scenario-based quizzes, and practice tests, check out our complete course, DPDP Act Compliance Masterclass on Udemy, linked in the description below. Also, subscribe so you don't miss what's coming next, and click on the DPDP Act Master Series playlist in the description for the complete sequence. Next up, we turn to the rights and duties of data principals themselves. See you there.